Brad Williams, Labor Compliance Group Newsletters. I'm going to present a series of newsletters, all travel and subsistence related to DIR, and it is shocking. I mean, literally shocking. So for the next 3 months, anticipate some just radical changes that DIR has implemented that can have serious impact on you, your companies, and your workers. And the end result is still up for debate. And I'm going to leave that up to you to give me feedback and let me know your feelings. If you're an attorney, please contribute your opinions. If you're not an attorney, just give me some feedback, because the rulings from DIR are shocking. So let's get started. This is a good newsletter in that it is an area of misunderstanding, and that is travel time. It is one of the subjects that no one can seemingly define, and DIR attempts in this civil wage penalty assessment to clarify some of the wording within their required travel and subsistence. Let me explain what I'm trying to convey here. We have an $87,000 civil wage penalty assessment, and it started with Caltrans. Just FYI, they are a legacy labor compliance program, and they internally do their own prevailing wages, their compliance, and what have you. Only when there's a civil wage penalty assessment is when DIR gets involved. And just for clarification, I'm not a lawyer. I'm not giving any legal advice. I'm just giving you my impression of the civil wage penalty assessment. It's $1 million project in Sacramento, it appears. And in this particular case, Dreambuilder Construction Corporation is located in Southern California. The project is in the counties of El Dorado and Sierra project, but then further along in the reading here, it said something in Sacramento, and I'll try to clarify that. They have a notice of withholding of contract payments served on April 30, 2021 by Caltrans to this group. And they're stating there was an underpayment of prevailing wages, fringe benefits, training fund contributions under Labor Code 1775 and 1813 for a total of $87,000. The hearing occurred over 5 days, January 13th to February 9th. We have a hearing officer, Drayton. Brandon Reeves appeared for Caltrans, and Kovich appeared for Dreambuilders. Now, this is a lengthy discussion. I don't want to get into all of the record here. We have Caltrans employee, you have a bunch of people for Caltrans and a bunch of people for Dreambuilder. The argument here is travel time. So the merits are, was it a public works project? Was there a request for review timely? Any back pages paid? No. And then the discussion is, were the notices timely served? Yes. Whether Dreambuilder misclassified employees, whether Dreambuilder underpaid prevailing wages, whether Dreambuilder paid the correct prevailing wages, whether Dreambuilder paid the required overtime rate, whether Dreambuilder was required to pay prevailing wages for travel time to and from the project. This is pretty much the entire argument here. Whether Dreambuilder is liable for penalties assessed pursuant to Section 1775, 1813, whether Caltrans abused their discretion, and whether liquidated damages are required. Caltrans advertised a project, awarded the contract in 2018. Contract was to replace guardrails in El Dorado and Sierra County. The Sacramento issue, that's the Caltrans office in Sacramento, not the project. So Caltrans used that as a reference point. The notice to bidders was dated November. Okay, this is some superfluous information. Applicable prevailing wage determination, not an issue here. Here's the requirement. By letter dated December 13, Caltrans acknowledged that while Dreambuilder provided documents on September 24th, October 2nd, October 3rd, and October 28, 2019, Dreambuilder failed to provide documentation of the following: proof of hotel pay, missing copies of hotel receipts for every week ending used for every employee listed on certified payroll records, copies of canceled checks front and back, missing certified time records, missing employee on payroll, documentation for case advances, and garnishment. As I continue to point out, when DIR/Caltrans asks for request of information, it is specific. If you need more detailed information on how this works, sign up for my compliance course, and I walk you through the 6.5-hour training. On February 2020, Caltrans issued a final notice of payroll record discrepancy. Caltrans determined, based on its audit, the available payroll and contract records, that 15 Dreambuild employees were underpaid. They're going to go on and they're going to argue this thing that whenever there's travel here's Caltrans' argument. They're saying prevailing wages are required for travel time from Dreambuilder's office in Southern California to the project location. The argument is that's a 5 to 7 hour drive. Principal travel time is part of prevailing wages. That's correct. However, the requirement is, when is a worker under the control of the employer? That's the area of contention, because in a previous civil wage penalty assessment from I think it was 2002 or 2003. The same kind of language shows that travel time is a prevailing wage requirement, in that an employee is always under the control of the worker throughout the life of the project, and a huge penalty was assessed. Here, DIR is taking a different route. They're saying, yes, travel time is required. If you're driving to a project past the free zone, then you have to pay the travel time to the project. Now here, we have a 6-month project. The argument that Caltrans is using is that anytime a worker drives back to Southern California, you as an employer have to pay that prevailing wage. DIR states otherwise. The travel center, as defined by Caltrans, is 4044 North Freeway Boulevard, Sacramento. That is the point of calculation. So you start in Placentia, California. You figure it's 5 to 6 hours to this point, and that is on record what the prevailing wage requirement, how it's determined. So 15 of the 16 Dreambuild employees listed in the CPR resided in Southern California. Caltrans determined that 7 hours was a reasonable estimate of travel time each way between Dreambuilder's yard and the Sacramento Travel Center. Dreambuilder employee, okay, they're going to say some other employees lived in San Francisco Bay Area, another one lived in different. Okay, the question is, were these workers paid travel time? And the question is, yes, they were. He traveled to and from the project site from his residence in LA in a Dreambuilder truck. That's important. Another guy drove in his own vehicle. Dreambuilders, this is how they operate. They testified that the company is located in Southern California, has been in business since 2006. Primary customer is Caltrans, formed over 100 projects for Caltrans since 2006. Dreambuilder does Caltrans projects in all 12 districts throughout California. President of DreamWorks, Singh, duties include his estimating and project management, and is responsible for estimating this project. He testified that he understood the requirements apply with prevailing wage law, and he did not recall seeing any requirements to pay for travel time in the specifications for the project. According to Singh, Dreambuilder employees lived all over California, sometimes in great distance from the Placentia yard, Lancaster, Salton Sea, Northern California. He told employees that Dreambuilder works projects all over California. Projects last many months, requiring the workers to be away from home for long periods of time. Dreambuilder workers are informed by the foreman of the location of the project, dates and times of work, and where they will stay during a project. To staff projects, foremen determine which employees are willing to work on a project. Singh testified that Dreambuilder's policy was to pay travel time for the trip to the project at the beginning of the project, and to pay travel time for the trip down at the end of the project. In other words, pay for the project driving to and travel time driving back. Dreambuilder's travel policy was put into written form in response to Caltrans' claim in this case in the beginning of 2020. He asserted that the unwritten policy was in existence for many years and that it was communicated to all workers when they were hired. Singh also stated that he provided a vehicle and a fuel card for employees who wish to go home on weekends. It's important. He testified that although employees were expected to stay at any project location for the duration of the project, the majorities do not stay. Also responsible for booking the hotels for Dreambuilder employees. He explained that he attempted to book hotels as close as possible to a specific project location. Singh testified that the employee would need to let him know if the employee arrived in Northern California on Sunday or if the employee was staying for the weekend so he could book the hotel room. Singh asserted that Dreambuilder had no control. Here's the important area. No control over the workers during the time spent traveling to and from the project. For instance, Dreambuilder did not control when the employee had to leave their home. Instead, Dreambuilder required employees to report to the job site at the assigned date and time. Singh testified that the project was a daytime, Monday through Friday project with only 1 or 2 Saturdays work. Singh testified that he believed these workers stayed near the project site on weekends. Testified that this guy also may have stayed weekends. There was at least one weekend during the project and employees worked on a Saturday, and that employees stayed over the weekend. Regarding the witness declaration submitted by Dreambuilder, Singh testified that his role was to request Dreambuilder employees attend a meeting in Cerritos. Singh explained to the workers that the goal in obtaining the declaration was to substantiate the procedures for Dreambuilder's travel policy and hotel stay. Here, the foreman, when he proposed the different projects to workers, he gave them that option without any repercussions if they wanted to take the job or not. They were never forced to work a specific project. It was voluntary. Further, again, this is the foreman. He believed that the written travel policy existed. Okay, this is just some other documentation. If employees wanted to stay at the hotel over the weekend or other non-work days, such as the account of rain, they would do so at Dreambuilder's expense. Employers worked and stayed over the weekend on at least 2 Saturdays for the project. This is going to go on and on and on. DIR and Caltrans are trying to sort through this entire deal. Here you're going to have some individuals that they drove back to Southern California on Friday in the company vehicle, then drove back Sunday night to show up at the project and worked all Monday through Friday. This is a recurring theme. They were never forced to stay in Northern California. And in this last paragraph, it states right here, the written testimony was similar, revealing that the employees were informed of the job location and duration before they started work on the project, and that some employees were supplied with a company vehicle, mostly those with the status of foreman, which they used to travel to job sites of whatever distance necessary, and they did not pay for the vehicle fuel. Other carpooled, either in the company truck or with another employee in a personal vehicle. They stated that even though they could stay in a hotel on job remote from where they reside, they chose, quote unquote, chose to travel home on weekends to be with their families. California prevailing wage law states that the overall purpose of the prevailing wage law is to benefit and protect employees. Then we're going to go in and going to go through and basically state from the different laws and what have you, and I'm not going to get into that. Other arguments are compensable travel time. And although the time an employee commutes to work is not generally compensable, the Supreme Court recognized in Marillion versus Royal Packing that travel time may, and again, this is a loose word, may be compensable depending on the level of control exerted by the employer over its employee. In Marillion, agricultural workers were required to meet at specified required, right? That's the key word here, required to meet at specified assembly areas to be transported by buses provided and paid for by the employer to and from the field. In this regard, the Supreme Court used the term compulsory travel time to refer to travel to and from a work site that an employer controls and requires in order to distinguish it from an ordinary commute from home to work and back that employees take on their own. That's critical here. The argument states that the Supreme Court held that the employees in Marillion were entitled to compensation for their compelled travel time under the applicable wage order because they were subject to the control of the employer during the time. So now the argument is Dreambuilders were willing to pay their workers to drive down. The workers voluntarily took that job. My opinion is Dreambuilders paid their workers to drive down and to drive back. What about in the interim timeline? In this 6-month period, just say there's 22 weeks, why is Dreambuilders not required to pay that travel time? Caltrans failed to meet its burden of proving a prima facie case. In other words, they couldn't argue who was in control of the worker. Under Marillion, the compensability of travel time depends on the level of control exerted by the employer over the employee. By requiring employees to take certain transportation to a work site, employers thereby subject those employees to its control by determining when, where, and how they are to travel. Caltrans contends that Dreambuilder employees were under the control of Dreambuilder during the time when they traveled to and from Southern and Northern California to work on the project. Now, if you go back and you read other civil wage penalty assessment, DIR followed this requirement and subject employers to serious compensable travel time. Without more, Caltrans failed to show that Dreambuilders determined when, where, and how its workers had to travel to the project. Caltrans provided no evidence as to the circumstances surrounding the travel. Unlike Marillion, where the ag workers were required to take the employer-paid transportation or risk discipline, there's no evidence in the record that the workers on the project were required to take certain transportation to a work site. The fact that some Dreambuilder workers traveled in Dreambuilder's vehicles is not dispositive. Time employees spend traveling on transportation that an employer provides does not require its employees to use may not be compensable as hours worked. That's huge because in other DIR documents, it says otherwise. Here, there was no evidence that Dreambuilder required its workers to drive or ride in company vehicles. The Supreme Court emphasized in Marillion that employers do not risk paying employees for their travel time merely by providing them transportation. Here's a travel and subsistence for labor, and it's 7 pages. I'm only going to point out one area here. Right here, it says, additionally, the employee will be compensated at a rate of 1/2 of his or her straight time wage, both to and from the job, less 75 miles each way. In this civil wage penalty assessment, DIR stating that travel time, there's no compensation for travel time. But then in this travel and subsistence provision, they go in and say, on projects 60 miles or more by the shortest and most direct regularly traveled route from the main office, established area of individual employee, such employee shall be provide each employee transportation either physically or by paying the cost. Okay, that's clear. If the employer chooses to pay the cost of such transportation, the cost shall be determined by the rate of, okay, that's fine. Additionally, the employee will be compensated at a rate of 1/2 his or her straight time wage rate, both to and from the job, less 75 minutes each way. What the civil wage penalty assessment stating? Again, I'm a little confused here. It says travel time, you don't pay. But then here in this travel and subsistence, additionally, the employee will be compensated at a rate of 1/2 his or her straight time wage rate, both to and from the job. In view of the finding that $87,000 penalty is waived, to support this channel, check out my courses. Here we have this great Understanding California DIR Labor Compliance Rules and Regulations. This is comprehensive. This is going to cover the A to Z of DIR in terms of legal compliance. Federal Davis-Bacon FAQs. This is I call it my pocketbook. This is just a go-to. If you're familiar with Davis-Bacon, but there's many questions related to Davis-Bacon, here's your source. San Francisco local hire. If you're doing work in San Francisco, you need to review this. Navigating DIR websites, more there than you think. There really is more there than you think. This is a complement to the compliance course. It is an absolute necessity. California Prevailing Wages FAQ, similar to this Davis-Bacon. If you're familiar with California Prevailing Wages, there's a lot of questions that you may have answers to, but then there's a lot that you might might not. This is, again, I call it just the handbook of FAQs related to DIR. Federal Davis-Bacon Contractors Guide. You're doing Davis-Bacon related work and you're shooting from the hip, don't. Take a look at this course. It's going to answer a lot of those questions that DIR is going to mandate. It's going to require upon you. And consulting. I still do consulting. If you want to do one-on-one training, still do Davis-Bacon and DIR related training. If you need a large project monitored, 5 million above, I'll take a look. And if you have questions that you can't find answers to, give me a call, email me. If this newsletter has been helpful, subscribe, give me a thumbs up, hit that like button, check out the links below. But here's the findings. All other issues are moot. In view of the findings, Caltrans failed to meet its burden. The issue of underpayment of wages, training funds, and overtime premiums are moot. Based on the foregoing, there's no penalty for underpayment of workers or any other fines. Interesting, especially when you look at this travel time requirement for labor, and it says you got to pay travel time. Weigh in. Give me your opinion. If there's any lawyers out there, give me your 2 cents. Explain to the viewers what's right, what's wrong. I'm just trying to get clarification as to what is correct, why DIR is changing their tone here, and whether this travel and subsistence requirement and this compensation to employees is valid. Brad Williams, Labor Compliance Group. Thanks for watching.